Welcome, everyone. This is a webinar that the Society of International Economic Law is hosting, SIEL Conversation 1221. It's my great pleasure to welcome you to today's event, in which we'll discuss Caroline Foster's book, Global Regulatory Standards in Environmental and Health Disputes. As is true with all SIEL Conversations, we're recording this event, and all prior SIEL Conversations, just as this one, are available on our YouTube channel. Just search on YouTube for Society for International Economic Law and subscribe if you like. My role is very, very brief. I am immediately handing over to Andrew Lang, who will host today's meeting. But before I do that, I will very quickly put the link to the book and a discount for the book in the chat, so that anyone and everyone has the ability to access the book at a 30% discount from what I see, Caroline. And let me just say this before I hand over to Andrew. Congratulations to the book, Caroline. I will have a quick look and I will read with great pleasure. So, Andrew, over to you.
Thanks so much, Marcus. Welcome, everyone. I'm delighted to moderate this panel on Caroline's new book. We have three wonderful commentators with us, including Caroline herself, and my role is primarily to introduce them, but also I've been asked to say a few words to start with to introduce some of the book's themes and set it in its context. So first of all, a quick word about our panel members themselves. And I will give a formal introduction to each so that you know a little about the background of all of them. So Dr. Caroline Foster is Associate Professor at the Faculty of Law at the University of Auckland in New Zealand. She serves with the New Zealand Centre for Environmental Law and on the editorial advisory boards of the New Zealand Yearbook of International Law and the New Zealand Journal of Environmental Law. Earlier in her career, before becoming an academic, she served as a legal and policy advisor for the New Zealand Ministry of Foreign Affairs, as well as working at the New Zealand High Commission in London. And she served as New Zealand's representative at international negotiations in a number of different areas of international law. Dr. Penelope Ridings, Penny, has served for many years in New Zealand's Ministry of Foreign Affairs, where she's been both Chief International Legal Advisor and Ambassador. And in those positions, she's accumulated extensive dispute settlement experience in those roles. She was, for example, New Zealand Agent, Counsel and Advocate before the ICJ in the whaling case, Counsel and Advocate before ITLOS in respect of the advisory opinion on illegal, unreported and unregulated fishing. She's been an independent panelist in disputes before the WTO, represented New Zealand as counsel in WTO cases. So an extensive body of experience there, and I'm delighted that she's now also New Zealand member-elect to the International Law Commission. Professor Stephan Schill is Professor of International and Economic Law and Governance at the Faculty of Law at the University of Amsterdam. He's also General Editor of the Yearbook of Commercial Arbitration, General Editor of ICCA Publications and Co-Editor-in-Chief of the Journal of World Investment and Trade. Professor Schill also has practical experience in international law and dispute resolution. He's admitted to the bar in Germany, in New York. He serves as an expert and arbitrator in international arbitrations. He's very well known to many of you as an author in investment law, dispute settlement, and including its relation to other regimes of international law. And he'll be known to many of you as the author of The Multilateralization of International Investment Law, as well as general editor of Schroyer's Commentary on the ICSID Convention. So the order of speaking today will be that I'll say a few words and then Caroline will speak to introduce some of the key themes of the book, then Penny and then Stephan. So very briefly, the problematic that Caroline tackles in this book is really a central problematic of international law, which is how international tribunals should go about reviewing domestic regulation and regulatory processes. This is a familiar problematic. With what standards, from what perspective, in pursuance of what role. And that problematic is usually conceptualized in terms of space. How much space, what kind of space, for what? It's not a problematic which can be resolved in any simple way. It keeps re-emerging year after year, decade after decade, in the context of new regulatory challenges, new regulatory priorities of states. And the challenge for adjudicators in this area has been to craft a set of principles which somehow stand the test of time, but which are flexible to adapt, and flexible enough to adapt to these new contexts as they arise. So that's the thematic of Caroline's book. And the way she approaches it, I think, is remarkable for its breadth and depth. So she studies this problem in the jurisprudence of a range of different international tribunals, ICJ, ITLOS, the field of international investment arbitration, and also WTO jurisprudence. And within those broad fields, she focuses in specifically on regulatory disputes around health and environmental matters, where this problematic that I describe looms very, very large. So Caroline's approach is jurisprudential, but it is synthetic and interpretive. So from this very disparate practice, she distills three principles, what she calls global regulatory standards. These are regulatory coherence, due regard for the rights of others, due diligence in the prevention of harm. And I'm going to leave, I could say very much about these three principles, which I find incredibly interesting. But I will leave Caroline to elaborate those a little more. As I said, I think that it's a synthetic account. It distills these principles from quite disparate language, but in a very persuasive way. And I think already that distillation is a real contribution to the literature. And I think it's likely to be a reference point of conversation for the scholarship as we go ahead. Now, as I read the book, I feel as if Caroline's approach is characterized by an attention to deference, and in particular to the question of legitimacy, which are two connected questions. Are tribunals sufficiently deferential? Do they overstep their boundaries? Given that these principles are to some extent judge-made, what can we say about their legitimacy? How might arbitral, judicial, quasi-judicial practice in this area be made more legitimate? And from that perspective, and I don't want to speak for Caroline, but by way of introduction to the book, Caroline argues that in the context of the principle of regulatory coherence, that means-end proportionality tests should be limited to their weak version, in the language with which we're familiar, rather than proportionality stricto sensu. She argues, I think, in a very important contribution in favor of an extension and development of the due regard principle, in particular as an important route to greater legitimacy. And also, and I think this follows from her attention to the breadth of her attention to the range of different international tribunals that she's interested in, she also argues for greater attention, I think, on the part of adjudicators to the problem of fragmentation in the formulation and application of these standards. So this work, I think, raises an important set of questions and provides one really fascinating set of answers to them. So is a single set of standards appropriate across all these domains? What does legitimacy mean in the context of meta-regulatory standards rather than regulation themselves, where meta-regulatory standards can themselves, from one perspective, be understood as a legitimizing framework? What does it mean to generate legitimacy? Is the aspiration to create a set of standards appropriate to regulatory disputes generally? Should that be our aspiration, or should we distinguish between different kinds of regulatory disputes, different regulatory challenges? But our commentators will have their own questions. We have only an hour. It's very much time for us to turn to the discussion. So as I say, firstly, Caroline, it's for you to introduce your remarkable work and your thoughts, and I turn it over to you now.
Enga mana, enga hawe wha, taina koutou katoa. Nau mai, haere mai. E ko ana tana kau, kua tai mai koutou, ki te whakanui I te kaupapa o te rā. Nō reira, e aku rangatira, taina koutou, taina koutou, taina koutou katoa. To the esteemed of the four winds, welcome to this event. Colleagues, I greet you all. And thank you, Andrew, for your kind introduction and for introducing these themes of deference, fragmentation, legitimacy, and universality. We certainly have plenty that we could talk about. Thank you also to Marcus and Maria Laura for organising this conversation, and thank you to Penny and to Stephan for participating. So I wrote this book as an academic based in New Zealand, a Southern Hemisphere state with a large exclusive economic zone, an economy in which agricultural and horticultural exports are significant, a developed country far from Europe and the EU, and for whom the international legal order in general is important. And as Andrew said, the book sits in a context where there is intensified globalization and economic integration, where international law reaches increasingly further into domestic legal orders, far more so than previously, and where there is an attempt increasingly to try and balance states' competing international interests in human well-being. And all of this is inevitably generating disputes with which international courts and tribunals have to deal. So the research for the book started with a generalized perception that international courts and tribunals have been having increasingly to find ways and methods to work out the extent of states' regulatory freedom and obligations in this interdependent world. And of course, these regulatory disputes do often arise in quite difficult and highly politicized situations, so it's challenging for international courts and tribunals. So I did focus on decisions involving environmental challenges and the protection of human health. These are among the most important areas where states need to regulate. And what I found were striking commonalities in aspects of what international courts and tribunals are doing and saying across fairly diverse areas of international law. So the book has 2 chapters on the ICJ, the International Court of Justice, the International Tribunal for the Law of the Sea, and arbitral tribunals operating under UNCLOS, and interstate arbitral tribunals, including in the Permanent Court of Arbitration. It has 2 chapters on WTO panels and the appellate body, and it has 2 chapters on the decision-making of investment treaty tribunals in cases where foreign investors take proceedings against regulatory and administrative action by governments to protect human health or the environment, or that is said to be for those purposes. And together, the decisions of these bodies featured an emerging set of precepts which international courts and tribunals have been identifying by applying interpretive principles of contextualism and effectiveness, and a solid dose of logic as well. Precepts for how international law says that states should go about their regulatory activities. And I call these precepts global regulatory standards, following the distinction in the literature between rules and standards, according to which any given law might incorporate both rules and standards. The content of a rule is generally well specified. The content of a standard is not, and may require to be determined through subsequent judicial or administrative processes, in this case, judicial processes. So, for example, a law prohibits reckless driving. A court reads into this that people should adopt a standard of driving that does not endanger other road users. And likewise, the authoritative articulation of the standards embedded in international legal provisions helps capture the balance of legal interests embodied in these provisions and renders the provisions more amenable to consistent application. So the book calls the standards that I was finding global standards because they're appearing across so many different areas of international law, and also because of their importance to the developing structure of international law. So to be clear, the meaning of standard in the book is different to the idea of international standards that we rely on when we talk about standards in a context of harmonisation, food safety, product quality. And it's also different to when we talk about standards in reference to investment protection guarantees or disciplines like fair and equitable treatment or national treatment. The term regulatory is used to encompass regulatory and administrative activities broadly. So let me introduce a little bit more the 3 standards that emerged from the research on these cases, and then introduce 3 more overarching analytical propositions. I should say that the 3 global regulatory standards can be applied using different tests in different legal contexts, but overall the commonality in terms of their emergence is striking. There are times when reference to the standards or tests appears on the face of applicable provisions, rather than requiring to be read into the text. But international courts and tribunals must nevertheless elaborate the standards by developing formulae for what they will mean in practice. So the emerging global regulatory standards that the research identified were due diligence, due regard, and regulatory coherence. Due diligence has become quite well known to international environmental lawyers in particular as the standard for the performance of obligations to prevent transboundary harm and harm to common spaces. So states' obligations when they sponsor deep seabed mining or exploration have been interpreted to require due diligence. They have to actively implement, monitor and enforce regulations designed to help ensure that the companies engaged in these activities don't cause harm. But states bear no strict obligation to guarantee or ensure that such harm does not occur. And we can think about the Seabed Disputes Chamber of the ITLOS's advisory opinion on responsibilities and obligations of states. We can think about the ICJ's Pulp Mills case. We can think about the ITLOS advisory opinion for request of the Sub-Regional Fisheries Commission and the work of the ILA and the ILC. Due regard is a more gradually emerging standard. It calls for states to have due regard in their decision-making for the legal rights or interests of others, for instance, by actively considering these interests. The language of due regard is most familiar to law of the sea scholars and practitioners, where coastal and flag states are to have due regard to one another's rights and duties. But it also increasingly appears in WTO dispute settlement, in interstate arbitration, and latterly also in investment cases. Regulatory coherence is already quite well established. It calls for regulatory and administrative measures to bear an appropriate relationship with their objectives. So, for instance, in the application of the investment protection guarantees of fair and equitable treatment, national treatment and expropriation, there is a raft of cases where investment tribunals have looked for rational relationships between states' administrative and regulatory measures and their objectives, the means-ends relationship that Andrew mentioned. In the WTO, we also see rational relationship testing in the TBT and SPS cases, as well as in the parsing of the non-discrimination elements of the chapeau to the GATT and GATT's general exceptions. And we have the capability and necessity tests in the GATT and GATT's exceptions as well. And of course, the structured test for what is meant by necessity in that context. A good example is the Australia plain packaging case. And it's especially interesting that the sort of regulatory coherence tests that we see here are now beginning to appear elsewhere. So, for example, in the ICJ, in the case of whaling in the Antarctic, Australia versus Japan, New Zealand intervening, in which Dr. Ridings appeared for New Zealand, the court based its decision against Japan on reasoning that read the International Convention for the Regulation of Whaling as requiring that the design and implementation of a scientific whaling program must be reasonable in relation to its stated objectives. So let me turn now to the three selected overarching analytical propositions, which deal respectively with the role of international courts and tribunals, the changing nature of sovereignty, and the development of the international legal order. The first point is that international courts and tribunals are playing a necessarily constructive or proactive role, and we need to accept that this is a product of what we're asking them to do when we submit regulatory cases to them. In this regard, it may be that certain of the criticisms of the WTO appellate body could be revised in light of an appreciation, as seen in this research, that all international courts and tribunals at this stage in the development of international law are more or less forced into the position of having to articulate and apply standards that will make the international legal provisions that they have to apply workable on the ground in order to resolve the cases coming before them. The second point is that these cases are reflecting and also creating a reconception of sovereignty and what it means to be a sovereign state in the 21st century. Sovereignty is changing. Global regulatory standards are articulated based on an inference that sovereignty is inherently constrained, as seen in an elaboration of tests for regulatory coherence. And this is especially noticeable when these tests appear in an unfamiliar or unexpected context, such as the whaling in the Antarctic case, such as the navigational rights case again in the ICJ, and also the Arctic Sunrise arbitration under the UN Convention on the Law of the Sea. In all these cases, and most notably the latter two, Limitations on how sovereignty should be exercised were implicit in judicial statements that government regulatory and administrative action and enforcement action should be limited to the reasonable, the necessary, the non-discriminatory. And sovereignty is also becoming more other-regarding, as reflected in the jurisprudence of the due regard standard. There are opportunities here for sovereignty to be reconstituted as cooperative sovereignty, in which obligations of both due diligence and due regard are embedded. Finally, the third point relates to the development of public international law as a whole, as a public international law system. These standards make us think about the place of private actors in public international law. The due diligence standard is to some extent an admission that states harbour ultimately limited ambitions to control private actors, especially in relation to private actors' activities beyond national jurisdiction in areas such as the high seas or space or cyberspace. The tensions relating to the place of the private actor in international law are especially visible in regulatory cases and investment treaty arbitration. It's especially important to promote increased debate also in this area in advance of the establishment of a possible investment appeals mechanism or court or courts, as seen on the agenda of the UNCITRAL Working Group 3 and in CETA. The book, in fact, works from the starting point that investment treaty arbitration is an exercise in public international law, in that it applies investment treaties and customary international law. Investment treaties are concluded between states for the mutual benefit of their respective populations. And really, for what other reason would they be concluded? Home states acquire the right to have their investors' investments treated in certain ways. Host states acquire the obligation to do so. This understanding feeds into the book's articulation of how investment tribunals and a potential investment court should approach the articulation of regulatory coherence tests, as Andrew foreshadowed. For instance, the book promotes restraint, as he mentioned, on the part of tribunals contemplating adopting tests under which they would assess the proportionality stricto sensu of states' regulatory measures as a means to determine the legality of those measures. Proportionality testing is a significant idea, though it might seldom form the actual pivot of an arbitral award. It formally lifts the power to make a value judgment on regulatory policy to the international level. And it invites the idea that public international law may be a system of law not just between states, but in which private actors have more standing than previously, especially if it's applied in a way that focuses on weighing up harm to the applicant investor versus benefit to the regulating state. The book suggests that if proportionality is going to be applied, there are certain ways in which this should be done that would be more consistent with an understanding of investment law as a law between states in which investors have procedural rights to arbitrate, rather than a law in which investors hold substantive rights themselves. And ultimately, and thank you, Andrew, for drawing attention to this at the outset, ultimately the book actually suggests that applying a due regard standard could be a better option than proportionality testing, i.e. that states would have to show they'd carried out an analysis before they took regulatory or administrative action, which evaluated the expected effects of their measure on the rights of the other state, including effects experienced by particular classes of investor, sometimes even, of course, a class of one. The book also suggests that if proportionality were to be adopted for general use as a regulatory coherence test, this should not be done by international courts and tribunals, but through considered and informed public processes with an eye to the legitimacy of the resulting international law enhanced by the new standard. Well, I'm going to leave it there now and hand over respectively to Penelope and Stephan.
Well, thank you very much first. Thank you very much first, Andrew, for that introduction. And also, I'd like to thank the Society for the International Economic Law for inviting me. And I want to congratulate Caroline on her excellent book. It's a real pleasure to not only have read it, but also to provide some comments on it. First, I want to raise some general points regarding the book's valuable contribution to international law scholarship. It's a very solid empirical research into the decisions of international courts and tribunals, which articulate global regulatory standards and in turn provide the basis for standards enriched in international law. It concentrates on disputes involving a state's regulatory measures in the areas of health and environment. But I've been especially appreciated that it takes an integrated and less fragmented approach to international law. By looking at different fields of international law and the different decisions of international courts and tribunals, ICJ, ITLOS, WTO, and investment arbitration, it seeks to get away from the international law silos in which we sometimes find ourselves. Importantly, the book develops an approach which seeks to find commonalities among the various decisions of courts and tribunals and between different fields of international law, where a government takes decisions on health and environmental grounds which impact on other states or interests. There's value in an approach which allows states to consider how to reconcile actions on the domestic regulatory plane with obligations on the international plane. As such, as Caroline identified in the introduction, the cases in the book are reconceptualizing what it means to be a sovereign state. But to my mind, the value of academic scholarship such as this is not only in explaining what has happened in the past and is value to the present, but also what can be applied in the future. The book gives a lot of food for thought about the future of global regulatory standards under international law. It prompts us to consider the way in which global regulatory standards can be used as a framework to guide not only international courts and tribunals, but also governments in the development of their regulatory requirements. So I see the book's value not only in providing guidance to courts and tribunals in assessing consistency of a state's regulatory action with its international obligations, but also in providing guidance to a state in assessing in advance whether its conduct would be adjudged to be consistent with its international obligations. But secondly, I want to address some of the regulatory standards in which I'm particularly interested. And I will use first due diligence, because that was the regulatory standard first raised in Caroline's book. She places due diligence squarely within the well-known environmental precept that a state's action should do no harm to the environment of another state or to areas beyond national jurisdiction. But as Caroline has already alluded to, due diligence can be used as a means by which to control the activities of non-state actors that operate outside the jurisdiction of a state. I see due diligence as having a wider application to activities of a state or its non-state actors, which have an impact outside its territory. So the potential ambit of recourse to due diligence is relatively broad. It can encompass areas such as law of the sea, international human rights, international humanitarian law, business and human rights, and new areas such as cyber and space. There's also a view, which Caroline ascribes to, that due diligence gives leeway to a state to essentially absolve itself of responsibility for its own actions or the actions of its private actors if it has tried to do its best. My own view is that there is value in looking more closely at due diligence as a regulatory standard to help guide states in how they regulate either their own activities or the activities of their non-state actors, which operate outside their territory. But to do this requires greater attention being paid to what kind of conduct is necessary in order to fulfill a due diligence standard. I also want to comment on the regulatory standard of due regard. As Caroline notes, express reference to due regard is found in the United Nations Law of the Sea Convention. But it is particularly apt for situations where potentially competing interests of state come into play, where one or other state should have due regard to the interests of the other states. This occurs in situations where there is a community or commonality of interests in ensuring the protection of a global public good, or where there are shared resources which require cooperative effort among states for their protection. In many such instances, due regard flows from the duty to cooperate among states. And this also appears to be the view of the International Court of Justice in the whaling case. I believe it would be helpful internationally to have a greater articulation of what is meant by the duty to cooperate in terms of what states must do in order to ensure that they fulfill their duty to cooperate with other states. But due regard, in part because of its link to the duty to cooperate, has potentially a broad ambit. Due regard is particularly relevant where one state must balance its actions and interests with the interests of another state. So this is most obvious in the law of the sea and international environmental law, both of which Caroline raised in her book. But it's also pertinent to other areas, for example, responding to global pandemics. A due regard standard tends to operate procedurally through suggesting that the domestic decision maker should consider in an appropriate manner the rights and interests of others. Due diligence and due regard do not get much traction in international investment arbitration. And in her book, Caroline suggests that due regard could be an appropriate regulatory standard in the decisions of international investment tribunals. However, I must admit that her view is grounded in the premise that international investment arbitration fundamentally relates to interstate rights and obligations and not to investor state rights and obligations. I do wonder whether this precept is fully reflective of modern international arbitration decisions, which tend to highlight the obligations owed by the state to foreign investors. And this is most obvious in cases where the tribunal has not taken into account the views of the investor's home state in interpreting the international investment agreement. But I will leave international investment arbitration to Stephan. But to conclude, the book, to my mind, is recommended reading for all of those interested in emerging global regulatory standards and in reconciling the tension between a state's regulatory freedom and international legal disciplines. So thank you very much, Caroline, for your book. I really enjoyed it.
Thanks so much, Penny. Stephan.
Yeah, so first of all, thanks a lot to SIEL for the organization and the invitation to be able to comment on this remarkable book. And of course, to Caroline, congratulations on researching it, writing it, and publishing it. So let me start with a set of issues that I would call praise, and then move over to the debates that probably this book will steer. So in terms of praise, I have 4 points that I would like to highlight. The first one is Caroline's book really understands international courts and tribunals as central actors in the international legal process. So they're not just settling individual disputes, they're not just finding pre-existing law and applying it to individual cases, but she really perceives international courts and tribunals as actively developing those global regulatory standards. And I think in taking that perspective, she really does justice to what international courts and tribunals do, and also to the central role that they really play in international law writ large. The second point of praise, I think, is the cross-regime approach that she's taking. So she looks at the ICJ, at PCA tribunals, ITLOS, UNCLOS tribunals, WTO, and investor-state dispute settlement. And that approach is an approach that shows that international law is not just developing through international courts and tribunals on a regime basis, but that there are really overarching issues that run across regimes. The third point of praise is that she really shows in this book the domestic impact of international law. And not only that international law affects domestic law and policy processes, but she really shows the centrality of public law thinking that by now we have in international law. So public international law, in the way she presents it, is really international public law. And the fourth point of praise is that she embeds all of these discussions in really larger themes and theories that have been around and central to international law and global governance for decades now. So she comments on sovereignty, suggests a reconceptualization of it as conferred power or states as trustees. She comments on fragmentation versus convergence across different regimes and dispute settlement mechanisms in international law. And she focuses on legitimacy of what international courts and tribunals are doing in their lawmaking activity. And all of this is embedded in reflections on theoretical discussions about various approaches to international law and global governance, global constitutional law, global administrative law, international public authority, and also comparative public law approaches. So that's the praise. And now let me comment on a few things where I think this book will really provoke and steer controversy and debate. And I think that's the most important thing that one could ever hope for a book to actually do. And the area I want to focus on is specifically the debate and controversy that I see this book steering in international investment law. And I focus on two things. First is Carolyn's conceptualization of investment treaty arbitration and the stance she takes on proportionality analysis. Now, Carolyn's conception of investment treaty arbitration, she really presents investment treaty arbitration as, alongside ICJ, PCA, ITLOS, WTO. So she presents it essentially as another interstate system of dispute settlement, not only in terms of what it is, but also what it should be. And she argues that it's a system where individual investors don't have their own rights, where regard should not be had to individual investors, but only to general economic interests of states and interests of their populations. And she makes a suggestion that standards on regulatory governance that have been developed by the ICJ, by ITLOS, by PCA tribunals, in interstate cases should also govern what investment treaty tribunals are doing in the way of developing regulatory standards. So I disagree with this conceptualization, and I think that it sits squarely with the idea of public law as governing public-private relations, not just an inter-public law. What's interesting, I think, is that Carolyn does not explore other analogies that are used to conceptualize investment treaty arbitration, other regimes of international law that also are sources of global regulatory governance, but that really fall outside the scheme of interstate systems. And those are particularly analogies with human rights adjudication. So they don't appear in the book, even though the various human rights systems, whether it's the European system or the inter-American system, they also create and produce regulatory standards. And what she also doesn't focus on are the different supranational systems, particularly the Court of Justice of the European Union, which of course also develop regulatory standards. Now, those attribute a central role to individual economic actors or individuals more generally. And if one analogizes investment treaty arbitration more with these standards, suddenly you see, or you can emancipate it from this interstate public law view that Carolyn has. And I think in the end, that interstate view really underestimates the importance that private actors have as subjects of international law under various existing systems of international adjudication that the book does not discuss. So maybe investment treaty arbitration is really the new normal and a reflection of the renewed or importance that international law should be giving to private actors. And a lot of the systems we see in the ICJ, in UNCLOS, in the WTO, are somewhat artificial shieldings that interstate international law has built, where private interests are really only mediated through interstate prism. So maybe it's not just investment law learning from these other interstate systems, but maybe these interstate systems also looking towards and learning from how investment treaty arbitration is trying to emancipate the importance of individuals. The second point I wanted to comment on is Carolyn's argument on proportionality analysis, and she takes a stance against it, particularly in the field of investment treaty arbitration, where that type of analysis has started to find roots. And I understand that, of course, she is critical of proportionality balancing because proper global legislative processes are missing that could counterbalance the power of investment treaty tribunals. But she also brings arguments that one often hears against proportionality analysis, that it's too vague and too subjective, and therefore is prone to giving international courts and tribunals too much power, to allowing them to intrude too deeply into domestic policymaking. And the alternatives that are suggested are then either reasonableness standards, or, as Carolyn suggests in her book, due regard obligations to account for regulatory coherence and testing the relationship between means and ends. Now, I'm not so sure whether due regard or reasonableness are actually superior and address problems of vagueness and subjectivity. So proportionality analysis, if you look at how it's being applied in a variety of supranational courts, in a variety of domestic constitutional courts, is a rather structured and methodical analysis. And one of the benefits that's seen there is that it is more structured and more methodical, and therefore puts greater restraints on decision makers, on courts, than reasonableness or due regard standards, which in my view are equally vague and difficult to operationalize. And of course, proportionality analysis has to be aware of the potential power and misuses that courts could make of it. And therefore, it's important to combine them with other theories of public law, and that's principally standards of deference that have to be combined with the different steps of proportionality analysis, and also paying attention to the issue of proceduralization rather than substantive review in proportionality analysis. So maybe the extent to which one is comfortable with proportionality analysis or is critical with it also has to do something with the socialization that the different scholars have. So my observation is that criticism of proportionality analysis often comes from common lawyers, and particularly from lawyers from Australia and New Zealand, maybe because domestically they haven't been as comfortable with and as exposed to proportionality balancing as lawyers in civil law jurisdictions and in some other common law jurisdictions such as Canada or the UK. In the end, my take would be that the proof of whether proportionality analysis or reasonableness or due regard standards are really superior and avoid problems, the proof will be in the eating, and we will have to boil this down to concrete cases to really see whether Carolyn's restraint that she preaches is better and reaches better results than proportionality analysis. Again, I enjoyed reading this book, and I love these points of controversy that it will likely raise. So thanks a lot.
Thanks so much, Stephan. We now have 16 minutes for discussion, including between our commentators and panel members, and also, more importantly, probably with the audience. So the format we have for this, like all SIEL conversations, is through the Q&A function at the bottom of your screen. So I would encourage all of the attendees, please, if you have a question, simply to press that button and start typing it in to the box, and that will pop up, and we can take it from there. So we have a good quarter of our time for this discussion. While you're doing that, let me just recap a few of the key points which I think were raised for you, Caroline, and then perhaps what I can do is ask you to respond to a couple of them, including one or two of the audience questions as they get typed in. So we had from Stephan, you know, the core question of, I guess, the relative merits of proportionality analysis versus due regard in terms of the outcomes, in terms of their operationalization and so on. The question of the state-to-state nature, which I think both Penny and Stephan raised in relation to investment treaty arbitration. Is it best conceptualized as a state-to-state system, or are we really talking at some level at a public-private system, or of course some kind of hybrid? Penny also raised this question of due regard and I guess I heard you, Penny, make a call for a greater articulation of the details of that principle, particularly, and I was interested to hear in the context of responses to the pandemic and other global crises, which I think is very important. And then I heard your point also, Penny, about the due diligence standards. Yes, of course, on some occasions it can be a way of reducing responsibility, but I note your point that actually, in fact, it can be a real value in guiding states' actions in terms of regulating transboundary harm and so on. So I think that was an important point also to make. I'm looking now at our chat box, and I think people are still typing in their questions. Carol, I'm going to hand it over to you to respond, I guess, to a couple of points that Penny and Stephan have made.
Thank you, Andrew. I particularly like the idea, Stephan, that the proof of the pudding is in the eating, and with Christmas coming up, I think we're all thinking about puddings at the moment. So yes, some of the alternatives to proportionality, we know there's possibly reasonableness. There's, of course, concepts of rationality, including the rational relationship to legitimate objectives, which is quite a bit more of an objective test than reasonableness, and perhaps has certain merit in that regard. And then there's the idea of due regard, right? So when we talk about due regard, in some ways what we're thinking of is perhaps what you might call a procedural proportionality analysis. And certainly that idea has come up in the context of human rights law in New Zealand and elsewhere. But we also see it in the international law context. If we look, for instance, at the decision of the Arbitral Tribunal in the Chagos Islands Marine Protected Area arbitration, where due regard was expressly articulated, although only for the purposes of that case, in a way that very much resembled a requirement that the UK in that case conduct an analysis which incorporated the sorts of elements that you might expect in proportionality testing. What I would say is that I don't suppose that arbitrators who are drawn to proportionality testing are necessarily going to stop applying that concept. But in the book, there's some suggestions for how they might go about that in ways that would be more consistent with viewing investment treaty law as law between states, so that they do focus more on assessing proportionality in relation to regulatory purpose, which we saw somewhat in Philip Morris in Uruguay. Also a recommendation that they look beyond the concept of the individual burden, which is becoming a little bit more popular, but seems to be drawn from the jurisprudence of the European Court on Human Rights, and I'm not much of an expert, but detect perhaps an influence from possibly German, Dutch, French public law as well. So looking beyond the individual burden and pulling back from that. And also that they look perhaps for only manifest disproportionality, perhaps as even a kind of a capstone check or a sort of verification that, all the ducks are in a row and everything passes the Smith test, based maybe on the rational relationship to legitimate objectives test. So there are some ideas. Andrew also drew attention, I think, to really the nature of what we have here, and your description of this, am I right, as analogous with perhaps human rights law. So thinking about that a little bit more, this is, of course, a procedure that takes place between an investor and a state, right? And then by some kind of practical shortcut, the remedies are awarded to the investor. But investment rights aren't human rights, even though, as well as due process rights, investors might possess, say, human rights to property that are recognised under some human rights systems, including the European Convention. And those human rights run in parallel to investment rights, and sometimes they overlap. Alternatively, there's the idea that we look for an analogy with human rights, right, as you were saying. But from the perspective in the book, that's a problem because it distorts perceptions of the nature of investment law, and it kind of invites investment arbitrators to contribute to the development of standards on ways that arguably could take us a little bit off track. So it invites arbitrators to think that investors do hold substantive rights themselves under investment law rather than just procedural rights to arbitrate. And that's significant not just for itself, but also because the thinking in these tribunals and on a potential investment court could influence the development of the rest of public law. And then there's the idea that, that is argued in the literature that perhaps investors and indeed corporate actors in general should be given formal legal responsibilities under public international law. And if they were to have both rights and responsibilities under public international law, then would they come increasing to influence its content? Are they quasi-subjects of international law? Would they become generative actors? What kind of system would we have? So in 80 years' time, will public international law remain an interpublic law? If it doesn't, what might we stand to lose in the process in terms of democracy and representative government? So we already have a lot of transnational legal ordering, but this might take us further. And if we do think that constitutionalization is important, and you mentioned this, if that would be advantageous, then would we want to start with the status of perhaps the individual person rather than the corporate actor? And that's not to say that businesses and corporate actors are not vitally important in the regulatory sphere. And often, of course, businesses ahead of government. You see it in terms of, planning for oil spills, dealing with oil spills. You see it with the Christchurch call after the mosque attacks in Christchurch in 2019, where big internet service providers and the government together developed the call to eliminate terrorist and violent extremist content online and set down principles regarding that. But I just wonder what government strategies are to influence the long-term systemic development of this legal system going forward and promote the advantages of an interpublic law. Andrew, shall I turn to Penny now, to Penny's comments that you helpfully summarised?
Yes, you can, though I noticed that in the interim, Rizwanul Islam, thank you very much for your question. If you can, I think the best thing is maybe to respond to Penny, but quite briefly, just to make sure to leave time to answer this question, which is on a different topic.
Oh, that's good. All right. Well, so I don't know what that question is, but you'll tell me in due course, I'm sure. All right. So also thank you, Penny, for the comments. And I do agree that in terms of due regard, there is a major opportunity here to develop further international duties to cooperate, seen, in the Rio Declaration and in many other places. And also that maybe due regard might be a kind of a glue that holds together the international community in what is possibly going to be a difficult, challenging century. Due regard could be hugely tested in dealing with climate change, but it might also help reinforce commitments on that front. It might even help governments to fight off investor claims by showing that their regulatory action is called for by and is consistent with their international legal obligations, including under the Paris regime. Due regard can also, of course, operate multilaterally as well as bilaterally. So we saw that with the whaling case, where one of the reasons why Japan did not succeed in defending that case was because it hadn't carried out an analysis to ascertain that lethal sampling wasn't being used more than necessary in relation to achieving the scientific program's objectives. Due diligence, yes, I agree, it would be really good to elaborate that further. The work of Professor Anna Peters is very interesting here, arguing that due diligence is an emerging structural principle of public international law crossing many, many areas, but still not a general principle of law because it serves different functions in different contexts. But the point is really telling. And the book that we're talking about today is also likewise suggesting that the emergence of due diligence in combination with other regulatory standards does seem to signal structural change in international law, a kind of a new layer of law, if you like, of practical significance. Let me think now. You also spoke about, Andrew, can you remind me what the third point was?
So around due diligence and its significance for states in guiding their actions around transboundary harm, I believe.
Yes, in the relationship between states and private actors. Yep, and I do think that that with the embracing of due diligence, we do need to, in some ways, accept the fact that the world becomes a place where the limits on the extent of public power vis-a-vis private activity are built into the law, and that is, it's hard to hope for more, I know, in terms of what governments can achieve, but at a time when private actors have the resources and the technical capacity to conduct a very wide range of activities that might need controlling, one always wonders if we should aim higher. But if due diligence is increasingly parsed and elaborated, it may be that we discover that, you know, the threshold is even higher than we thought. And certainly looking at the jurisprudence, it seemed to raise itself a notch between the original Severe Disputes Chamber advisory opinion and then the full advisory opinion of the full ITLOS in the Sub-Regional Fisheries Commission advisory opinion, which was interesting. And there's some discussion on that in the book for anyone who might be interested.
Thanks so much, Caroline. So what I'm going to do is I'm going to read out your question, Rizwanul. Now, if you, Caroline, I think if you click on that Q&A box, you'll see it there as well, just in case that's helpful. So, Riz, thanks so much. You say, while in principle, I would agree with Professor Schill's point on proportionality, are states ready for a more extensive use of the proportionality principle by international courts and tribunals? And if you don't mind, I'm going to broaden that question out a little bit for you, maybe, Caroline. And that really goes, I think, to the question of not just what was said about the proportionality principle, but about the role, and what you say, Caroline, about the role of arbitrators in building and developing these principles. Are states ready for a more extensive practice there? I mean, obviously, in very obvious ways, we've seen states push back against that in a variety of different forums. So how does the argument of the book sit in relation to those developments? And I guess even broader still, how does your argument for the development of these larger meta-regulatory principles at a supranational level sit with what we might a bit simplistically call, you know, the re-emergence of a kind of anti-internationalist sort of position within domestic politics around trade and investment and regulation and so on. So I guess just situating the argument of your book in relation to those two larger currents, Caroline.
Well, thank you very much, Rizwanul, and also Andrew. And I suspect that with the resurgence of nationalism, proportionality becomes more of a challenging proposition because, of course, you know, it could put a tribunal in a situation of having to make some kind of a value judgment, unless that were resolved earlier in the analysis. Are states really ready for a more extensive use of proportionality analysis? I have considerable doubts about that, but as Stephan says, it may depend partly on the cultural background and approach and socialisation of the actors concerned, which is different in different legal systems. However, I recently did a study on proportionality in the administrative law of England, Australia, New Zealand, South Africa, and Canada, and found that it's not a general head of review of administrative law in any of these jurisdictions, which certainly does tell us something. Although, of course, in terms of human rights, whether statutory or fundamental human rights, it is present in the jurisprudence of these countries. So just then thinking a little bit more about what it means for international tribunals to introduce proportionality analysis into one area or another, or all of international law. I think what the book's saying is that proportionality, in theory, you know, it's a bright light that could offer a balancing of public interests, which could be substantively an improvement on perhaps the accommodations that are already reached, or perhaps the lack of ability to reach sound accommodations of interests that are, you know, a good balance of interests. So substantively, it certainly holds quite a lot of promise. But then that leaves us with a kind of a question of procedural legitimacy about if it is to be introduced, who introduces it, and through what process. And that's where the book suggests that there is a strong argument that it would be through processes other than the work of international adjudicatory bodies that such a concept should be implanted in international law, largely because these bodies usually work in a context involving you know, contentious proceedings where the parties are the ones putting the pleadings, where there isn't a process of public discussion and deliberation around the development. And if we really are thinking about a global regulatory standard, then surely people in general, and not just those of us who speak the language of law, should be enabled to have an appreciation of what it is that we're potentially talking about, what a remarkable integrating force such a concept would be, and what, if you like, what a level of constitutionalization it would bring with it, rather than it coming into international practice through the decisions of small expert ad hoc tribunals.
Thank you so much, Caroline, and perfectly timed. So I see that it's 10 o'clock, and I think to be respectful of everyone's time, we are going to call it to a close now. And so I guess it just remains for me to do so formally and to thank everybody. Thank you so much for our audience members who have participated and come along for this webinar. Thank you especially to our two wonderful commentators, to Penny and to Stephan, for taking the time and effort to read the book, to reflect on it, to provide your thoughts. That's a very generous act and very much appreciated. Thank you so much for generating this discussion. And of course, congratulations and thank you to Caroline, to you, Caroline. Well done on a fantastic book. This is really going to, I think, add in a really fantastic way to the literature in this area. It tackles the absolute heart of this field, and it does so in an original way. Well done, Caroline. We'll look forward to the next time we meet. Thanks, everyone.
Thank you very much. Good night, everyone.
Bye.
Bye.